court is now in session. You may proceed.
We're back on record with the Chism.
Thank you, Mr. Ritzer. Yes, please, Mr. Chism.
Thank you, Your Honor.
Your Honor, I have some submissions first.
Sure.
At this time, I'd offer an affidavit of Cecily Reardon. I'd offer a chart of defendants convicted of first-degree murder when juveniles.
Yeah, okay. We can mark these when you get up to speak, if you don't mind.
Oh, that's fine, but
Yeah, but go ahead, offer them now if you want to.
okay. A small portion of the DYS medical records concerning Philip Chism. The 18A report by Dr. Merritt. An affidavit of counsel concerning my advice to Mr. Chism, and a article from Nature magazine, a scientific article, Rethinking Schizophrenia.
All right. I will look at the ones I haven't already read over the lunch break. Yes, please, Ms. McDougall.
Thank you, Your Honor. Your Honor, as the court is aware from the Commonwealth Sentencing Memorandum, the Commonwealth's recommendation in this case is that as to the first-degree murder under which the defendant was convicted both on theories of extreme atrocity and cruelty and deliberate premeditation, the defendant should be sentenced to a sentence of life with the possibility of parole at 25 years. With respect to the two other convictions for aggravated rape and armed robbery, the Commonwealth is requesting that the defendant be sentenced to life sentences concurrent with each other and consecutive with the murder conviction with a possibility of parole at 25 years. I would tell the court that an enormous amount of thought, debate over the course of hours, if not weeks, and frankly agonizing went into the Commonwealth's recommendation. We've struggled to balance our commitment to the Ritzer family and their wishes, which were all too understandable, with the deep respect for the decision this court will have to make under the legal framework that I would suggest is unique and somewhat uncharted, and where there isn't that much guidance for this court, with our fundamental mandate of ensuring public safety. Because as certain as the defense is that this defendant is capable, if not amenable to rehabilitation, the Commonwealth, all of the investigators in this case, all of the prosecutors in this case, are equally certain that Philip Chism poses an enormous danger to the public in general and to women in particular, and that it is a danger that will not in any way be diminished by the passage of time or by chronological maturity. Your Honor, this case, these crimes go far beyond heartbreaking and horrifying that we deal with, unfortunately, every single day. Simply put, these are crimes that make one's soul ache. I could not ever hope to capture the loss that has been suffered in this case any better than the family and friends that the court has just heard from. This was, by all accounts, a remarkable young woman who not only gave an enormous amount in her life, but had an enormous amount left to give. Teachers change lives. And we know about the students that Colleen affected. We will never know about the students whose lives might well have been changed if she'd been given the chance. I will just say this, Ms. Fogarty spoke about the fact that often when someone dies, particularly when someone dies in such an awful way, we have a tendency to martyr them, to make them a saint, and somehow the truth of who they were gets lost a little bit. I can tell this court that the Commonwealth has heard too many times from too many different people the exact same description of this young woman as unbelievably optimistic and full of hope and happiness and committed to the small things in life and committed to her family. We see that smile that gets talked about again and again in every single photograph. We see it in the moments just before her death, a death she never saw coming, a death she never could have anticipated, in a place where she should have been safe, in a community that should still be able to feel safe and never will again. During the jury selection process, Your Honor, there was a gentleman who was eventually excused because a good friend of his granddaughter had to transfer schools because she never felt safe again at Danvers High School. That is fundamentally unfair to every one of those students now and in the future, to every one of those faculty and to every member of that community. It will never be the same Danvers again. It will never be the same Andover again. I'm not sure any of us will ever be the same again. The other aspect of this case that is so heartbreaking and that frankly challenges everything we think we know about justice and the justice system is the defendant's age. The Commonwealth takes no pleasure in asking for this sentence on someone who is 14 years old. We're not looking for a pound of flesh. It shatters everything we believe to think that someone this age could commit this crime. It shook investigators in this case to their core. And the Commonwealth did not shy away in any way from looking for answers, even if they would prove to be exculpatory, even if they would prove to be mitigating. We looked, we investigated, we went to Tennessee. We retained someone who is an expert on the juvenile brain. We embraced the juvenile brain at every stage of this process. If there was something to be found, if there was some explanation, if there was some mitigation, if there was some mental disease or defect that would somehow make something about what happened here make sense, we were willing to take it on. There isn't. I stand here today, 28 months later, with the enormous record that this court has, both what was heard in court and what was heard in other hearings and was heard in the mental health proceedings in this case. And I say with confidence, there is nothing wrong with this defendant that we believe that could be fixed or treated, or that in any way, shape, or form explains or mitigates what he did, or suggests to anyone that he has a real potential for rehabilitation and that he won't continue to pose a danger to the public. The guidance that this court does have in sentencing in this case comes from not only Diachenko, but the Costa decision, which certainly offers the court some guidance and the factors you can consider in forming a sentence in a case like this, to the extent there is any other case like this. And the court is certainly familiar with the Miller factors outlined by the Supreme Court in Miller. I would respectfully, they're obviously detailed more significantly in our memo, but I would walk through them briefly. Obviously, the first one is the defendant's chronological age and its hallmark features, among them immaturity, impetuosity, and failure to appreciate risks and consequences. Certainly, it is indisputed that the defendant was 14 years old and I believe 9 months at the time of this offense. He was at the youngest range he could be to be prosecuted for murder as an adult. But I would respectfully submit that there is nothing about this crime that reflects immaturity, impetuosity, or failure to appreciate risks and consequences. On the contrary, everything we know about this defendant, everything in the record in this case, indicates he understands very well the consequences of his actions, at least as they have applied to him. The second so-called Miller factor is the family and home environment that surrounds the defendant. I would never presume to stand here and characterize someone's childhood or someone's life. I've done too much, spent too much of my career prosecuting child abuse to ever do that. Homes can be difficult for kids. Certainly there is conflicting evidence as to the extent of trauma, if any, that the defendant experienced as a young man, but there is no doubt that this was not a particularly healthy marriage that he witnessed, and that at a minimum there was a father who was absent and there was a mother who was struggling. There were a lot of moves, particularly there was a move from Tennessee to Danvers. There is also, particularly based on the testimony in this case, a wonderful group of people who helped raise this defendant, a wonderful group of people who supported and loved this defendant. There is also evidence that this defendant, unlike some of the concerns the Miller court voices, had the capacity to cope, had the ability in finding the Carter home, in relying on Claudia Rodriguez to find safe places for himself, to protect himself in the way that the Miller court worried that a child truly living in a badly abusive, neglectful, and broken family wouldn't be able to do. This defendant had those outlets, and that didn't change as dramatically as we would be led to believe when he moved to Danvers. This court had an opportunity to hear from the two young men who made a connection, in particular with this defendant. From a lovely young man, Ramsey S. Garcia, and from Kevin Hebert, who talked about how his family embraced the defendant, brought them to their men's Bible study, made him a part of their lives. I'm not suggesting the move wasn't traumatic. I'm not suggesting the move wasn't difficult, but I would suggest it does not rise to the level of chaos and abuse and neglect that in any way explains what happened in this case or in any way justifies or mitigates the defendant's conduct. The third factor is the circumstance of the homicide offense, including the extent of the defendant's participation in the conduct and the way familial and peer pressures may have affected him or her. That's just not here. The defendant acted alone. He acted under no one's pressure. He was subject to no peer pressure of any kind. He was sober. He was coherent. He did this on his own, of his own volition. The fourth factor is whether the defendant might have been charged and convicted of a lesser offense if not for incompetencies associated with youth. For example, the defendant's inability to deal with police officers or prosecutors, including on a plea agreement, or the defendant's incapacity to assist his or own attorneys. Again, that's just not present here. There was no lesser offense. There was no plea bargaining. There was no time in terms of the evidence that was admitted in this case where the defendant didn't have the utter wherewithal to make whatever decisions he needed to make. The court saw that throughout this trial. The fifth is the possibility of rehabilitation. The defense in their sentencing memorandum submit primarily, I would suggest, based on the defendant's age and what they believe to be his psychological infirmities, that he is amenable to rehabilitation. The Commonwealth would respectfully disagree that anything about his conduct in this case suggests that he is, and I would only as to this very limited issue note what happened at DYS. There is nothing about what happened at DYS in June of 2014 that suggests this defendant is amenable to treatment. This defendant, once again, purposefully and planningly took steps to avoid detection, snuck down a hallway, and brutally assaulted a young woman in a bathroom for the sole purpose of considering whether or not the defendant is amenable to rehabilitation. The Commonwealth asked the court to consider that event. In terms of Costa going on beyond Miller, you are asked to consider, the judge is asked to appropriately consider evidence concerning the defendant's then extant psychological characteristics in the process of assessing the Miller factors. And the third factor is not particularly relevant to this case because it has to do with the defendant's post-sentencing conduct. So I want to return to that second factor regarding the psychological characteristics of the defendant that the court is aware. The court is uniquely positioned in this case, even before this hearing, to consider those factors because of the evidence that was adduced at this trial regarding the defendant's psychological condition or lack thereof, and I'm not going to, the court certainly is well aware of the evidence in this case, and I'm not going to repeat all of it. I would submit that what is significant about Dr. Nancy Heaven's testimony regarding the testing she did and the findings she made is solely to rebut the claims made in the defendant's memorandum regarding the importance and value the court should put on Dr. Jackson, on apparently Dr. DeVere, despite the fact that she never examined the defendant, on Dr. Merritt's limited findings in the 18A, although apparently the defense would like the court to ignore the further findings she made in the two competency reports, as well as the findings of Dr. Dudley. Nobody, to the Commonwealth's best recollection, who found the defendant to be suffering from any sort of significant psychological trauma at the time of this crime considered the evidence of malingering. And I would respectfully submit that you cannot credit that evidence unless they have at least assessed the possibility of malingering. We heard again and again that malingering doesn't necessarily mean there's not a mental disease or defect, and I'm not suggesting otherwise, but you have to at least factor it in. And if you don't, it's suspect. And nobody says that there is anything significantly wrong with the defendant's thought process, thinking, or psychology at the time of this offense, who has considered the possibility, the likelihood, I would suggest, and the overwhelming evidence of malingering in the aftermath. And I would respectfully tell the court, sometimes we just don't need the experts to tell us, to give us the information we need about how a defendant was able to function, about the psychological characteristics of this defendant at the time of this crime. Because in this case, we have video. This court had a chance to watch the defendant, to see the defendant in the minutes leading up to this crime, in the hours leading up to this crime, from the time he arrived at school. in the immediate aftermath, when he leaves that bathroom the first time, as he moves around the school, disposing of Colleen's body, as he moves around the school afterwards, and even as he goes to the movie theater and to the BJ's. The defense suggests in their sentencing memorandum, and I expect will suggest again, that because this crime is so incomprehensible, and more importantly, because the defendant is described so universally as being the way he was described as being in Tennessee and being in the time leading up to this crime, there must be something wrong. There must have been some kind of break. There must be something that suggests there's mental illness here. The Commonwealth would suggest that there's a different view of that evidence, of these factors, particularly in light of the video that the courts had a chance to see, and that this is a defendant who is capable of moving among us. This is a defendant who is capable of functioning and presenting as completely normal and no threat, while something very dangerous and scary is lying below the surface, while he is planning to do something truly horrific, while he has just done something truly horrific. He is able to have a conversation with Kevin Hebert that Kevin described for you, that you could see on the video, his body language, his demeanor, and no one would ever have understood what he had spent the last hour doing to Colleen. He was able to then go to the movie theater and buy a movie ticket, go to Wendy's and get a burger, and most tellingly, I would suggest, walk through the BJ's, and the court can see him, saw him, his body language, his, I would suggest, relaxed behavior as he drinks from a sports drink, as he carefully eludes security to take the knife that he wants. The first time that this defendant shows any signs of being not with the program or having any kind of problem is when he encounters police, when he is caught on Route 1 with a dead girl's underwear and a bloody box cutter, when it served his purpose to behave that way. And I would suggest to the court, without going into all the details, that there is an overwhelming thread throughout the records in this case that this defendant is manipulative, that this defendant is incredibly narcissistic, that this defendant is capable of great harm and is capable of fooling people into misunderstanding who he is, that this is not a sick child, but that this is an incredibly disturbing young man. Your Honor, I want to return from the Miller factors to the crime that this defendant committed and to what it tells us about his inability for parole and for, frankly, what it tells us about what sort of a sentence he should receive. Because although it has gotten lost in the shuffle of Miller and Diachenko and everything that has come since, ultimately punishment is an appropriate goal of sentencing. And this is a crime that deserves punishment. Punishment within the bounds of the law, within the bounds of the state of the law in Massachusetts at this time. This crime was intended to violate Colleen Ritzer, to humiliate her, to torture and brutalize and take her life. This crime, the murder standing alone, I would suggest, justifies the maximum parole eligibility available to this court as to the murder charge. This is a first-degree murder committed with extreme atrocity and cruelty, and those words have perhaps never had quite so much meaning as in this case. This defendant could not have treated Colleen with more disdain solely in the acts of murdering her. The Commonwealth utterly respects the verdict of the jury with respect to what happened in the woods, but then much of that evidence, I would suggest to you, becomes part and parcel of the murder. It's undisputed that she was posed. It's undisputed that she was left in the way that she was left, both to humiliate her and to horrify those who were going to find her. There is no other reason to leave her the way that she was left. What she endured in terms of the murder alone is unimaginable. The strangulation was enough to kill her, but he didn't stop. At least 2 or 3 of those stab wounds were enough to kill her, but he didn't stop. He cut and he cut and he cut. That took some amount of time. It is unimaginable what she went through in that bathroom as to the murder alone, but the murder in this case doesn't stand alone. The defense seems to suggest that because he did all of these crimes to one person in one place, somehow they are not deserving of consecutive sentences, and I would respectfully disagree. even in a situation where the Commonwealth were able to ask for life without parole, frankly, this is a case where I expect that we would ask for consecutive sentences as to the rape and armed robbery, even if they were only symbolic, because there has to be some acknowledgement of the additional pain and suffering that Colleen went through, particularly with respect to the aggravated rape in the bathroom, the additional humiliation and terror that she experienced. Nothing on the videos makes clear whether the defendant was actually masked when he went into the bathroom. Frankly, it's the Commonwealth's hope that he was, and that Colleen didn't know that the person raping her was a student, was one of the people to whom she had dedicated her entire life to helping, was the same young man who she had just told Sarah Giaquinta she thought was in her classroom trying to make a connection because she didn't know why else he would be there. What Colleen experienced in that bathroom is every woman's worst fear. Sexual assault is different. It changes the fabric of our society. It changes how women conduct themselves in the world, how they operate, how and where and when they can feel safe. Your Honor, with respect to the 2 youthful offender convictions, I think it's easy for them to get lost in the scope of the total horror that the defendant inflicted on Colleen in killing her. And sometimes the impact of those particular crimes is better seen in the small moments. Ms. Ritzer talked about having to be brought in to be told what happened to Colleen in the bathroom when the forensic evidence became available in January of 2014. And she talked about it in terms of that she knew when she came in. And she may well have known. But we saw 2 people, 2 parents who were already broken beyond repair, who were already shells of the people they had once been. And yet, as we delivered the news that Colleen had been raped in the bathroom, we saw a whole new wave of pain. We saw a whole other part of them die. It's not part and parcel of the same crime. It was another crime. It was another injury. I remember Peg Ritzer saying to me, how am I going to go home and tell my daughter this? It's different. It adds something. The defendant was convicted of the armed robbery of Colleen's underwear, a trophy or a token he took, as the Commonwealth's memo indicates, not because of remorse or regret he was feeling at the time of this crime, but as a way to relive it, as a way to memorialize what he'd done. And the Commonwealth did DNA testing on the underwear, both in furtherance of the case, but also so that we could confirm it was Colleen, so that we would never have to ask a witness on the stand to identify her underwear. But when we were going through all the physical evidence showing it to the Ritzers so that they would be prepared to see it in the courtroom, when I pulled out Colleen's underwear from the bag, Peg Ritzer said she recognized it. Because Colleen was only 24 years old, and she was living at home, and her mom still did her laundry. And for Peg Ritzer to see that underwear and understand that it was torn from their daughter's body, that it was carried with the defendant, that it was on him when he was stopped in Topsfield, along with the bloody knife used to slaughter their daughter. That was another injury. That was more pain. That doesn't roll itself into any of the other crimes here, and that deserves its own punishment in this case. The Commonwealth is not asking for consecutive sentences as to those 2 crimes in respect for this court and in respect for the cautions that the SJC has issued in the cases and in the decisions in these cases. We are not trying to do an end run, but none of the cases cover the situation of a defendant who has committed separate and distinct crimes from murder, separate and distinct crimes that are deserving of punishment as well. Your Honor, in closing, I would just quote, and certainly as a prosecutor, I don't ever hope to be quoting from a dissenting opinion, but when I read the Miller decision, I was struck by language that the Chief Justice used in his dissenting opinion. Mercy toward the guilty can be a form of decency, and a maturing society may abandon harsh punishments that it comes to view as unnecessary or unjust. But decency is not the same as leniency. A decent society protects the innocent from violence. A mature society may determine that this requires removing those guilty of the most heinous murders from its midst, both as protection for its other members and as a concrete expression of its standards of decency. As judges, we have no basis for deciding that progress toward greater decency can move only in the direction of easing sanctions on the guilty. Our SJC has decided to ease sanctions on the guilty. The defendant will benefit from that. He will have a meaningful opportunity for parole. The Commonwealth is asking that that not happen for 50 years. Thank you.
Thank you, Your Honor. 8 years before October 22nd, 2013, Philip Chism was 6 years old, and he was starting first grade. He was learning to read and learning to play soccer, and he had a baby sister. 4 years before October 22nd, 2013, Philip Chism was 10. He was living in Florida and enjoying the ocean for the first time. 2 years before October 22nd, 2013, Philip Chism was 12 years old. He was learning to play competitive soccer, and he was beginning to explore his interests in languages and drawing. And as we know all too well, on October 22nd, 2013, Philip Chism was 2 months or almost 2 months into 9th grade and 14 years old. The changes Philip Chism experienced in the years before October 22nd, 2013 will be dwarfed by the changes he experiences in the next 5 years, in the next 10 years, in the next 20 years, in the next 30 years, in the next 40 years, and on. Now, that's why it matters that he was 14 on that day, not because it makes him more sympathetic or because it helps us understand what he did that day. Because the fact is, I don't know how anyone can say he or she understands what happened that day. As has been so well expressed here today, it's not to be understood. Not then, not now. The Commonwealth talks about possibilities, that there are other possibilities besides the explanation of mental illness, etc. And that is the whole point, Your Honor. The whole point is that we don't know. We can't know now. And as the years go by, it may be determined that there are reasons not to release Philip Chism, public safety reasons. And the life sentence on the murder and substantial sentences on the youthful offender convictions that the court is bound to impose will be there to ensure that that can happen. There's no suggestion here, not from us, that these crimes don't warrant severe penalties. But the sentences imposed must allow for the possibility of consideration of release. Because Philip Chism, and there's a reason, it's not just because the court said so. It's because Philip Chism will change and mature, and the understanding of what he did may grow and become clearer. The ability of society to address his actions and what drove them may get to the point where public safety can be guaranteed and he can re-enter the community as a contributing member of society. I know, and I'm going to acknowledge right now, that there are those in this room and those outside of it who feel in the most profound way that Philip Chism can never be allowed to leave prison, and that that very possibility dishonors the tragic loss that has been suffered, and that the safety of the public can never be sufficiently assured. To those people, I do venture to say, I understand those feelings. I understand, but our society and our highest courts tell us that there is too much we don't understand about human nature and about development and how life changes to absolutely close the door to the possibility of evolution and change. So, as we know, the U.S. Supreme Court and the Supreme Judicial Court have recognized this in ruling that life without parole sentences for juveniles are in violation of the U.S. and Mass constitutions. Now, this development in the law is not some radical departure historically. Before 1996, let's remember that the juvenile courts had the authority to determine whether or not juveniles charged with first-degree murder would be tried as adults and punished as adults, or treated as juveniles and subject to commitment to DYS. It was only for a period of 16 years that juveniles convicted of first-degree murder were sentenced to mandatory life without parole, which of course now has been ruled to be unconstitutional. And this is a good moment to recognize that Philip Chism, at 14, was younger at the time of these crimes than any juvenile homicide defendant convicted of first-degree murder during those 16 years. The only 14-year-old that is convicted of first-degree murder since 1996, and in recent history, as far as I can tell. I wouldn't say that absolutely, but as far as I can tell. In Diachenko, the SJC told us, simply put, because the brain of a juvenile is not fully developed, either structurally or functionally, by the age of 18, a judge cannot find with confidence that a particular offender at that point in time is irretrievably depraved. And we know from the amicus brief, this is by the AMA and the APA in Miller v. Alabama, that each time this court, that is the U.S. Supreme Court, has examined the constitutional limitations of imposing severe penalties on juvenile offenders, the scientific research on the development of the adolescent brain has grown. It's as simple, Your Honor, as saying we don't know what we don't know, but what we may yet come to understand as time passes. Certainly the fact that the SJC has ruled that mandatory life without parole sentences and de facto, or the functional equivalent of life without parole sentences, are unconstitutional in the case of first-degree murder convictions, means that the same result can't be accomplished by sentences on the youthful offender indictments. In Brown, the SJC cited the Null case out of Iowa with approval, and Null specifically condemned the idea of a geriatric release as not providing a meaningful opportunity to demonstrate the maturity and rehabilitation required to obtain release and re-enter society as required by Graham. Now, despite the tone, I would say, of the Commonwealth's argument and memorandum and the pre-sentence investigation, Philip Chism's life didn't begin on October 22nd, 2013. Who he was before that day cannot be reconciled with his actions on the day of the crimes. This is all the more reason to be sure that there exists a door that can be opened to the possibility of release in the future. The possibility, Your Honor, of Philip Chism being different isn't just theoretical. He was different. He was different from what those acts suggest. The witnesses from Tennessee and Danvers testified consistently that he was well-behaved, thoughtful, nice, kind, respectful, smart. He had strong interests. He was an avid reader. He's a learner of languages, and he was embraced by those around him. So what happened? What happened? And that's it. We stand here today not understanding. We don't know. We know that there is evidence that his brain is different from his peers, or at least a group of similarly aged teens. Different in ways that academic researchers have correlated to differences seen in the brains of individuals suffering from schizophrenia. We know that brain imaging is advancing the understanding of mental illness and human behavior, both in terms of normal human behavior and in illness. We know that in our lifetimes, we've seen dramatic changes in society as technology develops at lightning speed. What we don't know is how research and improved tools, as well as the changes in Philip Chism himself, as time goes by, might help us to understand what happened to this 14-year-old youth. Not only to understand what happened to him, but to ensure that he won't hurt anyone ever again. The Commonwealth seems to rely heavily on his failure to take medication one morning when he was being released from Worcester State Hospital to return to court, to suggest some strategic taking or refusing of medication, I presume in the attempt to discredit the possibility that mental health treatment might address what led to his acts on October 22nd, 2013. But the fact is, he's taken the medication almost without fail, and the improvement in his mood and behavior has been well documented by the clinicians both at Worcester State Hospital and DYS. And I'm not here retrying the psychiatric issues that were tried at trial. The issue is no longer what was his state of mind on that day. The question is, what happened to him, what is happening to him, and what might we learn in the future as the years go by. No one is saying that substantial sentences should not be imposed on the youthful offender convictions, or that parole eligibility on those offenses must mirror that of the parole eligibility on the murder conviction. In its memo, the Commonwealth argues that concurrent sentences, well, and in its argument certainly, would fail to hold the juvenile accountable for those additional crimes, but I suggest that that's not the case. A concurrent sentence need not be coterminous, and it can sufficiently satisfy important sentencing considerations without violating Article 26. But the overall parole eligibility must allow for a meaningful opportunity for release. In order to accomplish this, the court should impose concurrent sentences that allow for parole eligibility no later than when Philip Chism reaches the age of 40. In our memo, we discussed some ways to think about that, since there's no ruling yet on, were the court, for example, wanting to do what the Commonwealth has suggested, which is impose, and I would suggest what also the Ritzer family has suggested, the maximum penalty allowable by law. The question then, if that's what the court decides it wants to do, the question is, what is that? And we don't have a number for what that means. We have some guidance and some ways to think about it. Certainly not a geriatric release, we know that, and not the sort of number suggested by the Commonwealth, since 50 years, or the age of 64, is comparable to the sentences determined by other jurisdictions to be the functional equivalent of life without parole. Those cases are cited by the SJC in the footnote in Costa and referred to by the Commonwealth in its memo on page 33. Those sentences specifically were a 50-year sentence, 52.5-year sentence, and a 45-year sentence in the Bear Cloud case. Costa itself, I'd suggest, is not apropos to the situation we face here in this case, because it's a case before, when the parole board was still aggregating from and after sentences. So the specific discussion in that case doesn't apply here. In the words of the U.S. Supreme Court, an unacceptable likelihood exists, I would say in these difficult cases, that the brutality or cold-blooded nature of any particular crime would overpower mitigating arguments based on youth as a matter of course. And this is what the court here must guard against. And I'm going to close here with some thoughts from the amicus brief in the Miller v. Alabama case. And it's the amicus submitted by juvenile court judges. So here's the guidance the juvenile court judges in the Miller case give us. They said, but amici firmly believe that it is impossible to tell at the time of sentencing which juveniles will prove capable of reform. The fact that a person committed a crime as a juvenile, even a heinous crime, does not tell us who that person will be as an adult. The brief goes on to point out that amici strongly believe that juvenile offenders, including those convicted on homicide offenses, deserve an opportunity to turn their lives around, and that the best time to evaluate whether they have successfully done so is after they have had time to mature, not when they are initially sentenced. Based on decades of experience sentencing juvenile offenders, amici simply do not believe it is possible to tell which youths will change and which will not at the time of their initial sentencing. Thank you.
Thank you, Ms. Oka. The court will do its best to make a sentencing decision by 2 o'clock today. Court will be in recess.
All right. Court will be.